ऐसे और वीडियोस के लिए इस चैनल को सब्सक्राइब करें। 3, 2, 1 स्टार्ट।
The defendant appellant claimed to be in possession of the property, though without a title nor any document there being on record as such at his behest to show his title to be legally vested in him since 1942. The plaintiff respondent's case in the suit was that the status of defendant appellant herein was that of a tenant over disputed property, as he was inducted as a tenant at the rate rupees 5 per month by plaintiff number 1, which was payable as rent, and since he has committed a default in paying the rent since 1st June 1958, his tenancy as per the plaintiff respondent's case, it deserved to be terminated. Para. The property in question which is disputed constitutes to be the property as described in suit number 66 of 1965. The predecessors of the present defendant appellant were tenants over part of it constituting to be the property bearing municipal number 139 Dehradun, on which there existed a Laxmi Narayan temple, and the property in question as per record of rights and title was vested with the deity of the said temple, which was being managed by the plaintiff numbers 2 and 3 as described in the suit number 66 of 1965. Para. It would be necessary to precisely deal with the issues which were adjudicated by the learned trial court, which was decreed for eviction and recovery of damages. The learned trial court, while answering the first question that the plaintiff number 1, that is the deity, is not the owner of the property and has decided the issue numbers 8 and 17, and while deciding the aforesaid issues, the learned trial court had observed that the manner in which the managerial rights of managing the property of the plaintiff number 1 were flown from the present plaintiff numbers 2 and 3, the deity plaintiff number 1 would be owner of the disputed property and plaintiff numbers 2 and 3 as to be its managers by succession from their predecessors through lineage. Para. The nature of the controversy involved in the second appeal and which has been raised in the present second appeal too would be having a very much wide bearing on an adjudication made on issued numbers 1 and 2. It was to the effect as to whether there existed a relationship of landlord and tenant, that is between the plaintiff and defendant number 1. The learned trial court, after appreciating the evidence on record and also after considering the statements of the parties, has held that as per Exhibit 6 dated 17th April 1953, the rent was shown to have been remitted and there had been an evidence of an acknowledgement and a proof of the payment of rent up to 1958, and thereafter the rent was due to be paid after 1st June 1958 when the plaintiff number 1 through plaintiff numbers 2 and 3 issued the notice. Stop.